Hello landlords, it's Ernie, and I'm back this week to talk all about an appeal. We're in a series right now of videos having to do with the appeal process. Today we're talking all about what you can expect throughout this process. Let's get started. We appreciate all of the members of our Facebook group who are also subscribers here. If you are not a subscriber, please consider subscribing. But we're also interested in interacting with you, so we welcome your comments below. Give us a like. Let us know how we can serve you better. What kind of topics would you like to hear about? Tell us also what questions you might have. If it's something I can answer quickly, I routinely answer questions in the comments below, and we look forward to hearing from you. So the appeal process is a frustrating one. The majority of cases do not get appealed. The majority of cases are resolved in the justice court, and most landlords are the most comfortable in the justice court. Traditionally, it's an extremely speedy and very simple process, very few formalities in the justice court. The landlord will typically fill out a form, present their case orally, never present any evidence for review. Simply their testimony is generally enough for them to secure a judgment against their defendant and to recover their property in a few weeks. Generally speaking, in the justice court, the process is about 4 to 5 weeks, even with a tenant who is forced out with a writ of possession. 4 to 5 weeks and you get your property back. But things are different once an appeal is filed, and a tenant is allowed to file an appeal. We've covered this topic before, simply as a matter of law. They don't have to cite any error in the justice court ruling. They get one free pass as a matter of right to appeal the case from the justice of the peace to the county court. Now, this process is available through one of 3 mechanisms that the defendant can choose. The first is to pay a cash bond, which is usually some multiple of the judgment. Let's say you want a $4,000 judgment, and the court says, well, your cash bond is an $8,000 cash bond. If you can pay this, you can stay and appeal, and if you're a successful tenant, you can even potentially recover some of your cash bond, if not all of it. Most tenants do not pay a cash bond because of that multiple. Now, there are a few courts who, based on their own discretion, will set a lower cash bond, and sometimes that cash bond is more advantageous, but most of the time it is not. And so the last 2 options are usually where tenants go. The first is to go with a surety bond. That's getting a third person to sign on and say, yep, I can cover the cost of this. If needed, I'll back up this judgment up to twice the judgment amount. And this happens sometimes. Sometimes a tenant will get grandma to sign a surety bond, and now grandma is part of the lawsuit. Even though she's not a signatory on the lease, she's a third party removed from this contractual engagement between landlord and tenant. But by her own testimony, she can swear that she has enough assets or money in her bank account to cover the cost of an appeal up to twice the original judgment amount. So that's an option. Now, with this option, the tenant is required to pay monthly into the court's registry their rent. So unlike with a cash bond where all rent through the appeal process is essentially included, with a surety bond, the tenant will need to pay monthly into the registry. And that's also true of the appeal by affidavit of inability to pay, or what's commonly known as the pauper's affidavit. This affidavit allows a tenant to declare to the court, look, I can't pay a cash bond, and I can't even pay the filing fees. With a surety bond, the tenant at least has to pay the filing fees. In Harris County, it's about $250. And so with the pauper's affidavit, the defendant is saying, nope, I can't even pay that. So the majority of tenants fill out this form. It's very easy. It's hard to controvert. And essentially, they receive any kind of government benefit. It is an automatic. So for those of you who are interested in challenging, I talked a little bit about this in a previous video. I don't recommend it. Because one of the things that they are required to do still is to pay their rent into the court's registry month to month as it comes due. Their failure to do that, just like with a surety bond, would allow you to an immediate writ of possession. You got to keep tabs on those deadlines, though, and you got to make sure that the first moment you are entitled to a writ of possession, you get it, because the appeal process is a lengthier one than in the justice court. Generally speaking, I counsel clients and let them know, look, you're a landlord, your tenant has appealed, and you can expect the process to take no fewer than 30 days, sometimes 60 or more days. I usually give the 30 to 60 range because that's typically a pretty good approximation. The timetables are a little different. So for example, when you are successful in a justice court, you have to wait 6 days before you're eligible for a writ. In the county court, you have to wait 11 days, and that has everything to do with the number of days that are available for the defendant to file an appeal. So in the county court, the defendant has 10 days to file their appeal and to pay what's called a supersedious bond. Essentially, that's your best defense to an appeal. If you set a high enough supersedious bond, generally 10 times the monthly rent, you can set that in the judgment in the county court. You can prevent a tenant from appealing. Again, this is not always the case. Sometimes things don't go well for various other reasons, which we won't necessarily get into in this video. We'll talk about in the next video. But in the justice court, it's a much shorter process. The tenant has 5 days to appeal, and because so many tenants simply just don't show up to the court, they'll receive a notice maybe 2 or 3 days after the trial was held, and they don't know that they only have 2 or 3 days to act in order to secure an appeal. By the time they rush to the courthouse, that ability is gone. You've purchased your writ of possession and the process is over. But that's not true on the county court level. They have slightly more time. But if you've prepared properly, you've also given them a much higher obligation. And so typically any cases, or the majority of cases who have filtered from the justice court to the county court end at this level. A few trickle through, but those are actually quite rare. However, what we're talking about is what you can expect in terms of length. And definitely the county court is a lengthier process. In many cases, you're going to have to set all of your own hearings. In justice court, things are much more automatic. They don't expect someone to have counsel. They don't expect anyone to have a really thorough knowledge of the rules. And so the justice court does the majority of the work for you. You file, they set all the hearings, they set all the trial dates, they send notice to the opposing party, they send notice to you, everything's in writing and delivered through the mail. But at the county court level, much more responsibility falls on the landlord. For example, in Harris County, the courts issue trial notices with orders that say you are hereby ordered to send a copy of this notice to your tenant by certified mail. And I have seen courts who just straight up ask, have you delivered this? Your tenant is not here. I wonder if it's because you did not deliver notice to them. And if you haven't, then your case is reset and you are ordered to issue notice as stated in your trial setting. And so that's a formality that sometimes gets landlords in trouble. Make sure that when you receive your trial notice, if your trial notice has an order, that you deliver that notice to your tenant, that you get that done. Other formalities include having to prepare your own exhibits. If you are presenting your case to the county court, one of the things you're preparing the case for is the potential for an appeal. Again, so few of these cases actually ever get appealed that this may never actually amount to anything, but the court's going to require it. Generally speaking, you need a copy of your lease to be your first exhibit. You need a copy of your notice to vacate, that's your second exhibit. I also recommend preparing a rent ledger if your case has to do with non-payment of rent. If it has to do with some kind of other non-rent violation of your lease, I would include any notices of default or any communication of that default in which you inform the tenant that they have violated the lease. You've informed them in writing and then later delivered a notice to vacate. All those are helpful exhibits and very common in this practice. Other things might be invoices or photographs, sometimes video, which is a little harder to get in, but any additional evidence, you should be prepared to submit it to the court so that it goes into the court's record. If you have not done this, it is very likely that you will be turned around and told, prepare your exhibits properly, and we will reset you a week or 2 or 3 weeks from now. And so that formality, again, because you're preparing this case potentially for an appeal up to the Texas Court of Appeals, that formality is required, and many judges will not allow you to proceed without meeting these formalities. So be prepared for that. The final thing that you have to contend with landlords is the lack of direction from the court. I think people get a little comfortable with the justice of the peace and the fact that they seek out assistance from the clerks in the justice court. And although clerks shouldn't be handing out legal advice, it's quite common for them to do it. Sometimes it's not the best advice. So I certainly don't encourage landlords to get their advice from clerks working at the justice court, but you'll find that typical friendliness or that willingness to assist that may be present in the justice court really isn't present in the county court. The formality that I discussed earlier kind of bleeds into this area where the clerks are going to tell you, you need to contact your own attorney, you need to get legal counsel from some other source that is not the court. And in fact, when you present your case, generally speaking in the justice court, the judge will lead the questioning, the judge will ask you for certain documents or ask for certain information from those documents. So some justices are a little more formal, and they'll say, look, I've left a script, or when you filed, you were given a piece of paper and asked to present this information to me. But again, that's them laying out the case for you. In the county court, you may find that the judge simply sits there and waits. Tell me what your case is about. And if you fail to meet your burden and prove all the essential elements of your case, you cannot be issued a judgment for an eviction. So be prepared to present your case and to lay out all the facts. You know that you're preparing a case for eviction based on either non-payment of rent or some lease violation. So be able to establish first and foremost with your first exhibit that you have a contractual relationship with your tenant, that the tenant is in violation of that contract, and that you properly notified the tenant of that violation. So each of these steps is an essential part of you establishing that you have a superior right to possession of the premises. If you're able to do this, you will be issued a judgment. Now, naturally, these kinds of formalities and these kinds of issues tend to be the reasons that landlords seek out attorneys. If you have a question that you're facing because you're presented with an appeal from your tenant, you'll see that my contact information is here below. You can reach out to us by phone or by text or by email. If you have a quick question, I don't mind answering those quick questions. However, if you need something more extensive, like a consultation, feel free to call Monday through Friday, 7 to 7. We'll take your call and book an appointment for you. We offer a 30-minute consultation. The link in the description below where you can book your own consultation if that's something you're interested in. Again, I have one more video that I'll be doing in the near future on the subject of appeals. If you'll look, YouTube thinks that this video is something that you'll find helpful. You'll see a picture of my face right here. If you have not subscribed yet, this is a good way to subscribe so that you are constantly in touch with us and the content that we release. In any case, we thank you for coming. Don't forget to hit the like button below, leave a comment, and again, if you haven't subscribed yet, that's a good idea at this point. In any case, happy leasing.